Hello and welcome to that Encyclopedia podcast with your hosts, myself, Will, and Jacob.
Hello.
We had to sort of delay this episode slightly because when it came to recording, although I had read about it a bit, I didn't feel like I'd picked up sufficient detail to actually talk about it. I don't know if I have now, but we'll give it a go. We are, of course, talking about the Dred v. Sandford case, which is a sort of decade-long fight with the courts by Dred Scott, who was an enslaved black man during the 19th century, where he pursued and persisted throughout a number of courts, reaching the Supreme Court of the United States, and the Supreme Court ruled that he was not entitled to freedom. But more than that, the Supreme Court made some decisions and interpretations of the Constitution that sort of rattled the whole United States and had significant implications for the legality of slavery, and really gave abolitionists some momentum in the anti-slavery movement. So arguably was a major stepping stone to the Civil War itself. Yes, we are talking about this case today. And the Wikipedia page is long and goes into some detail, but we will try and distill the case and sort of submit to you what the case is, what the outcomes of the case were, and why that was significant in the history of the United States of America. First thoughts, Jacob?
Oh boy. I mean, to be fair, we selected this article because of its complexity. It's a good challenge for us, and it's a litmus test for discussing future matters of jurisprudence and litigation, be it in the United States legal system or other legal systems around the world. Neither of us are specialists in judicial matters, but given that the laws of the country affect everyone within its borders, I think it's important to at least have a go at understanding some significant decisions and their immediate impacts, and of course their more wide-ranging impacts further down the line. And through that lens, this case, Dred Scott v. Sandford, is a perfect storm, because not only does it combine complicated and very, very controversial, even for the time, legal arguments and decision-making processes, but it also has sprinkled on top this context of slavery in the United States, which ultimately, and this case would ultimately add fuel to that particular fire, and is considered by many to be one of the causes of the American Civil War that would break out just a few years later in the 1860s. So to answer your question, well, I think my thoughts on this case are that it's not particularly good. It is the article discusses this at some length, I think, but even for the time, it's the decisions that were made and the verdict that was reached, so to speak. I think verdict might be the wrong word. It's not like a criminal trial, but the decisions that were made flew in the face of not only just a priori logic, but also kind of countermanded and dragged into the foray what should have been settled and kind of not directly related political talking points. like trashing the Missouri Compromise as unconstitutional. But let's take a step back and start from the beginning, because there's so much to touch on here.
Let's talk about Dred Scott.
Yes, let's talk about Dred Scott. So as Will mentioned, Dred Scott was an African American who was born into slavery in Virginia originally, and ended up, it was kind of purchased, and he and his family, they ended up in Missouri, which was a slave state in the US. And he was owned by a couple of families throughout his life, but mostly by an army doctor, I think. Emerson, is that his name?
Dr. John Emerson, yes.
Emerson, that was it, yes. However, as part of his slavery under Dr. Emerson, he and the family moved around. And so although they started in Missouri, they actually, they were in Missouri for a bit, but they ended up in Illinois, and Illinois was not a slave state. And so Mr. Scott argued quite brilliantly, I think, actually, called into question what the limits of slavery were. He essentially argued in the courts, because of course it doesn't start in the Supreme Court, it starts in his local courts, and then as decisions are reached and appealed, it bounces its way up the court system in terms of seniority. He argued that even though he was born into slavery and was legally a slave in Virginia, in Missouri, he should not be considered a slave in Illinois, or indeed in any part of the United States which did not recognize the legality of slavery. And so actually argued that as soon as he'd crossed that border into Illinois, he should have been considered free. And therefore, going back across the border in the other direction into slave states could not re-enslave him, so to speak.
If I could interject, interject on this point, there, but, I just want to highlight the importance and underline Missouri Compromise. I think is an extremely important part of this case. So, not just is it like the way that Dred Scott attempts to argue for his freedom, but this compromise was, at the time, the legislation that balanced the desires of the northern states with the southern states. It was a balance that permitted slavery in some parts of America and forbid it in others. So the fact that this, which we'll come on to in greater detail, the fact that this was something that the Supreme Court disputed meant that the Supreme Court were disputing and taking down the compromise that the northern and southern states had already made with each other. So this was the agreement that was allowing for peaceful coexistence between North and South. But thanks to the Dred Scott v. Sandford case, it was destroyed. And I think that is extremely, extremely important to the eventual incitement of the Civil War. But we can go back to the story of Dred Scott now.
Well, I think also just to reinforce your point there, Will, not only was this kind of the destruction of the Missouri Compromise through the court system, like using Dred Scott v. Sandford as a vehicle, extremely dangerous to the health of the nation, but it was also weird because to people who know their judicial history, the Missouri Compromise had already effectively been repealed 3 years before this decision was made and before the case was heard through the Kansas-Nebraska Act of 1854, which, as the name suggests, created the territories, later states of Kansas and Nebraska in the west or Midwest of the US. And the details of the Kansas-Nebraska Act basically negated the Missouri Compromise de facto, even if not de jure. So it was really strange, in a way, for the US Supreme Court to call out the Missouri Compromise 3 years later, after it had already been kind of kicked to the curb. And I think just served to add fuel to this fire and reignite a controversy that everyone kind of wanted settled for one reason or another.
I guess there was quite heated politics going on at the time, because that reminds me of the fact that it mentions how after this Supreme Court ruling, when the Republican Party, which is fairly fresh, introduces Abraham Lincoln as a candidate, Abraham Lincoln and his rhetoric essentially suggest that he is effectively ignoring the ruling of the Supreme Court in his perspective on slavery in the United States. So this sort of there is a little bit of like of rulings being made in this time being ignored by certain states. I mean, even like within the technicalities of Dred Scott's like circuit through the courts, there's discussion of how if he had like taken this argument to this state, they'd almost certainly have ignored it, whereas in this state they might have given it a chance, even though like we're talking about laws that are the same, right? They're interpreting the same laws, but different states have a different history of how they intend to interpret the laws. So I find it interesting that there's so much of this, of this is written here, but we're going to ignore it, and sort of somehow we can, but eventually that leads to some major conflict lines.
Yeah, absolutely. And so returning to the story of Dred Scott, having made this, I think, quite a creative argument. I really like this argument, actually, that as soon as he leaves a slave state, he's then automatically freed and can't be re-enslaved. He makes this argument in initially the Missouri State Court, and the Missouri State Court rules against him and says, no, you are still a slave under our laws. He then sued in US federal court instead, but that didn't work either, because the federal court decided that it had to apply Missouri law to the case, and so it kind of just went back to square one. But because he was now suing in federal court, he could appeal to the US Supreme Court, which he did. And the case was heard around the beginning of 1857, and then in March 1857, under Chief Justice Roger Taney, in a 7-2 decision, they ruled against Scott and his argument. However, importantly, they took it a lot farther, which, to be fair, the Supreme Court often does, because they only hear cases that have these broad constitutional, implications. But the court determined, essentially, that persons of African descent, so African Americans, in the continent, in the whole of the US, but it was just the continental US, cannot be or could not be, and were never intended to be citizens under the US Constitution. And therefore, not only was Scott incorrect, but he wasn't actually able, or should not have been able, to utilize the judicial system at all, because he was not considered a US citizen and didn't have any standing to file a suit, didn't have any right to sue. They basically argued that the Founding Fathers and the founding laws and legislations that they drew from in drafting the Constitution made a clear demarcation against African Americans, but I think particularly not even so much against African Americans, in as much as it was pro the white race. They made this distinction of this hierarchical distinction where the white founding fathers were only speaking of themselves, people of their own race, and everyone else was kind of implicitly excluded. This had the consequence that Scott was not considered a citizen of any country, stateless, alongside now every other African American in the US, and so didn't have any protections at all. And it's widely considered to be one of the worst US Supreme Court decisions of all time, and I hope this summary makes it abundantly clear why that's the case.
Yes.
That said, Will, I wanted to ask you, I think that this argument that the founding fathers basically were only thinking of the white race, that could be true, right? Like, it shouldn't have any impact on the legal protections of American citizens today. But many of the founding fathers were slave owners, right? And it does seem incredibly hypocritical of them to be kind of pro-freedom and equality and everything, given that information. And so although this Chief Justice Taney is squarely on the wrong side of history, I think what he has done is successfully identified that in this particular regard, many of the founding fathers were probably on the wrong side of history as well. Is that a valid interpretation, do you think?
I mean, I do find it fascinating conceptually that the Constitution, by not explicitly defining who it's referring to, you can then go and argue, oh well, no, they just forgot to specify that it was only white people. They just forgot that. Not like, even though it's not like they'd never met people who weren't white. So I find that intriguing. I mean, obviously, like the concept of this. Now, this is not. I'm not sure whether this was ever in. I don't know very much about the U.S. Constitution, but there is this famous quote found in the United States Declaration of Independence, which is the quotation, "All men are created equal." Now, that would be an intriguing concept to apply to a nation where you've then had to say, oh well, technically, when I said that, I've forgotten that it was possible to misconstrue men as including non-white men. It's really, but it is an interesting question of like what did they actually want when they wrote these things, because it's hard to really conceptualize looking back, because people's attitudes towards African Americans varied a lot, and they're so different to our perspectives today that it's a genuine question that is probably worth asking. Like, did they intend for African Americans to be able to become citizens? I mean, maybe it is more obvious that there wasn't an exclusion, and that's why this was considered so bad. But I think it's a valid question to ask, because the concept of like owning other human beings as property, and it does really indicate a multiple tiered hierarchy of people, and to have that yourself, and then to go on to say something like all men are created equal becomes a bit cloudy. Like, what do you actually mean when you say that? Do you actually believe that in the way that I interpret that? So yeah, it is.
Right. Like you're saying, you keep using this phrase "all men." I don't think you know what it means. Like,
no,
you know.
Well, that's the thing. Like, there's but there are people who at the time would have literally viewed slaves as subhuman, right? And if you're subhuman, how can you be considered a man in the concept
Right.
of manhood?
And you've touched on a few things here. So Abraham Lincoln, for example, and the movement that he spearheaded didn't, or for the most part, didn't actually object to slavery on grounds of racial equality, which is a common misconception. But unfortunately, the history of striving for equality is not as binary and smooth as we would hope it should be. Lincoln and his supporters kind of objected to slavery on more sort of Christian grounds, where they didn't see anyone as subhuman, as you put it, and that was why they objected to slavery. So they basically believed that no human should be enslaved, because if you can enslave a human, then well, what's to stop you from doing anything to any other person? So there was this sort of sense of fundamental equality to a degree, but once you get over that human line, which is not a very high bar, particularly to us, right? They absolutely did not see individuals of different races as equal to them. They just didn't see them as subhuman, like some of the slave owners clearly did. And following on from that point, the idea of what it means to have a particular race or to be of a particular ethnicity is largely a social construct, which always catches people off guard, because the kind of gut reaction is to say, well, what the hell are you talking about? You can look at a person and you can see that their skin has a certain colour. Sure. However, bear in mind, at the time this history took place, people who were of Irish or Italian or Spanish or any kind of Mediterranean descent were not considered white at all. Like the label of white was strictly reserved for the kind of European, Anglo-Saxon, North Germanic sort of tribes, if you like, of cultures. And that's why, or partially why, the immigrants from Ireland and Italy who came to the American East Coast in search of a better life were discriminated against themselves. And we could say on the grounds of race, which feels strange to us now, because now the perception has shifted. And it hasn't shifted to the degree that we've eliminated the concept of race from our psyche and our perceptions, but it shifted enough that we can now say, what do you mean your classic Irish guy, pale skin, ginger hair, whatever, is not white? That's ridiculous. But at the time, it wasn't ridiculous. And I would argue that that's because race is essentially a social construct. Genetics isn't, but when all of these people, when your parents or whoever, when you go and do a genealogy test and you find your X percentage this and X percentage that, that's precisely my point. It's an arbitrary mix from thousands of years of history, which is a unique blueprint, and the particular shade of pigmentation on your skin is really a completely arbitrary and superficial metric to measure anything, really. And that's, I would hope that that's the direction gradually our societies are heading now, to completely eliminate these biases and these discriminatory practices. But of course, at the time of the Dred v. Sandford case, it's a long way from that stage.
I think there's a lot that we could discuss along those lines. I think even with being a sort of rational person with access to up-to-date scientific information, it's still probably pretty difficult to undo things like your subconscious biases, because of the whole, I guess, evolutionary mechanism of the in-group, out-group. I think a lot of it comes down to it's just really useful to grow up in a diverse community so that is something that you see as ordinary and normal, and how you see a variety of people as your in-group and as other relatable human beings, which I think is one of the reasons why actually it is difficult to truly eliminate something like anti-black racism from the United States and even from parts of the UK, right? We've got, I think the UK is a good example for using like a crude statistic, because from my understanding, obviously this is using modern day classifications for race. Around 95% of people in the UK would be categorized as white. So actually, although we have a lot of diverse communities, we also have a lot of communities that aren't very diverse in the UK. And in those communities, children will grow up with potentially very limited exposure to people that aren't white and British. And that, I think, inherently makes it, especially if they've not been educated about like the fact that that's actually like that leaves them in a place where they've actually not been exposed to very much in terms of diversity in culture and appearance. That will lead to more subconscious bias or more jarring reactions when you've got to meet someone who, you know, maybe certain comments that you might instinctively think to make are actually not appropriate, you know, consistently asking someone where they come from, complimenting people for their ability to speak English, when in fact you've just asked those questions to a person who was born and raised in the UK. Yeah, no, it's just, I think it's an interesting thing, and even though actually the United States is a very, very diverse country, it's also massive, and the amount of diversity is extremely variable within it. And we're also talking about something that actually, on a historical level, is not that far in the past. Especially if we think about, even beyond slavery, legislation that actively discriminates against people on the basis of race. It's not been absent from the USA for that long. So if you think about growing up in a sort of rural southern community where your great-great-grandparents might have been like actively pro-slavery, we're not that distant from that, and we're in communities that potentially aren't that educated or connected to the rest of the USA. So ideas and cultural attitudes within families will persist to some extent.
And all of those reasons that you've just listed, all of those nuances and all of those sensitivities and all of this context creates a very fragile scaffold over a nation's development. And so when you have a case like Dred Scott v. Sandford that destroys it with a sledgehammer, like no regrets, is anyone surprised that it was one of the direct causes of the Civil War a few years later, that it was so widely kind of rejected afterwards and reviled? And it was stated in the article that the Chief Justice and many of his colleagues thought that this would be the final sort of settlement of the issue, that because they were the Supreme Court justices, to an extent, literally their word was law. If they came out and said, yeah, this is how it is, deal with it, that everyone would say, oh, well, these people have just decided for us, I guess we can stop arguing about it now. It strikes me as being the height of naivete, and it's interesting how the more things change, the more they stay the same. Something I wanted to ask you pertaining to this case, actually, in our final couple of minutes, is there's a line in the article that says the ruling is widely believed, or is widely considered, a blatant act of judicial activism. And judicial activism is sort of a philosophy, the antonym of judicial restraint, that holds that courts can and sometimes should go beyond the applicable law to consider broader societal implications of its decisions. In other words, to use your position as a judicial expert or a judicial authority to influence society, not strictly according to what the law demands, but what you believe it should be. And the article in Dred Scott v. Sandford, has this sentence that phrases it as a very negative thing, because in this context it was used negatively. I don't think that's controversial. But as a philosophy in a vacuum, it's opposed to this countervailing idea of judicial restraint, where you just follow the law and it doesn't matter whether the laws are crap or not. That's the law, so we follow them in our decision making. Where do you think you sit on this restraint versus activism spectrum? If you found yourself on the US Supreme Court, would you adhere to the laws regardless of your opinion, kind of personal opinion on them, or would you be an activist judge, or fall somewhere in the middle?
I think it's difficult to say. In terms of like the ideal structure of how something like the Supreme Court works, I do think that restraint is very important, because as a Supreme Court justice, you're not really an elected representative. You don't speak for the people. And so if you allow yourself to become more on the activist side of things, then I feel like you're leaning into a precedent that might be slightly dangerous, or actually, regardless of your intent, might be slightly counter to the long-term goals of improving society, because you're leaning towards a position of, well, if I can use my position here to rewrite a law in a way that I think suits society, but I know that that's not what already really is meant to exist in the law, then you are just legislating on purpose from a position that is non-elected, non-representative. It's not actually particularly democratic. So, whilst it's like potentially very important, I think this concept probably ties in quite closely to the more recent rejection of the Roe v. Wade rulings in the US as well, where like in reality, like although Roe v. Wade may or may not have been a justifiable ruling in the first place, I think it is probably true that if you want to protect something like a right to abortion, which was not specifically described in the Constitution, so even if it made sense to interpret it as something that could be protected, well, currently it's not, and the importance is that as long as something is ambiguous enough to be decided either way, you probably need to write a law on it, and you need to get your politicians to do that. Although, on the realistically speaking, it's very, very difficult to say that in good conscience and actually believe that's going to happen, because to pass an amendment to the Constitution is not something that I can foresee happening in modern America. There's just no agreement between the major political parties, and that's really why stuff doesn't tend to get done very quickly. It's not that one or another party is like entirely uninterested or dispassionate. It's the fact that to pass major legislation, you need to have a significant majority, which no one is ever going to get. and that's different to historically. Historically, there have been some massive majorities in the Senate and Congress. But I'll leave my rant there. Feel free to add your take on activism.
No, I think I largely agree, and I think we should conclude by springboarding off that point and answering the question that some people might have, which is, well, if this was a Supreme Court ruling, what happened to repeal it? Civil War notwithstanding. I mean, was it just ignored? No, it wasn't ignored. It was basically superseded by several significant acts, and of course amendments, as you were mentioning, to the Constitution, which is something that we struggle to envision happening in the current political climate. Firstly, the 13th Amendment was passed in 1864 and 1865, which outlawed slavery. And then there was the Civil Rights Act of 1866, which defined what citizenship actually meant for the first time and made all citizens equal or equally protected under the law. And then in 1868, the 14th Amendment was passed, which built on this concept of citizenship, particularly relating to the former slaves following the American Civil War. And then finally, the 15th Amendment protected the right to vote for American citizens. And between all of these, it overruled the Supreme Court decisions, because of course the Supreme Court is bounded by the US Constitution. So the easiest, well, not the easiest way, but the most straightforward way to stop or overturn a Supreme Court ruling, if you don't have a new court to do it for you, is to just amend the Constitution. If the court says the Constitution doesn't say this, you just add an amendment so that it explicitly does say this. And that's what happened to supersede Scott v. Sandford. But as we've said, whether that will ever happen again remains to be seen.
Just to make sure that our listeners exit on a more positive note, Dred Scott did gain his freedom eventually. A few months after the Supreme Court ruling, when Dred Scott was considered property of Irene Emerson, the wife of the prior Dr. Emerson, who had owned the family. Irene married a man named Calvin Chaffee. I don't know if I'm saying it right, or Chaffee. He was a US congressman, and he was also an abolitionist. So upon finding that his wife owned the most infamous slave of the time, he sold Scott and his family to a man who was the son of the original owner, and this man then freed the family in 1857. So
a good final result for the Scott family.
Yes.
And ultimately for the American people as a whole, after a civil war and several amendments to the Constitution.
Yes, a good outcome for his family. Unfortunately for him, he died about a year later from tuberculosis, because being free does not mean that you really gain that many opportunities in an America where you are constitutionally barred from being a citizen. But as we've seen, major social progress. We live in a better world today. Stay safe. Have a good week. Thank you for listening.
We'll see you next time.